Now, a very diverse Supreme Court over the years is going to have different sways and opinions. And one of the big things that the Supreme Court tackles is there a right to privacy in the United States? So the United States Supreme Court identifies a constitutional basis for a right to privacy that is protected from government interference. So, two very famous cases of right to privacy, you may have heard of this one, was Roe v. Wade. Uh, and Roe v. Wade is a case that dealt with abortion rights. So, a young woman named Jane Roe was about to have her third child, and she wanted to have an abortion. But she was living in Texas, which had very restrictive access to abortion. And she was basically denied the right to get an abortion. So she took her case and she went through the proper channels and eventually gets kicked up to the Supreme Court. Now, the Supreme Court has to decide, does a woman have a right to go and decide what's going on in her own body? Is there anything in the Constitution that spells out that we have a right to privacy? And what they go with is they rule in favor of her that she should have been granted the abortion and that there is a right to privacy. Now, that kind of stems from the due process clause of the Fifth and the 14th Amendments. Now, there is wording in there that says the government can't do anything to deny you any life, liberty, or pursuit of happiness. And the argument's going to be that since the government violated that in some regard for Jane Roe, that they had violated her right to privacy and that therefore she should have been granted an abortion. Now, this set the precedent that abortion should be legal in all 50 states. Now, we all know 50 different states have 50 different abortion laws, but the long and short of it is that the Supreme Court identified a right to privacy, which extends to you making your own decisions about your own body. Now let's fast forward to 2014. In the case of Riley versus California, I don't think anybody likes anybody taking their phone and looking at what's going on in it. Well, this is a case where a man named by the last name Riley, he was involved in gang activity, and one day him and his gang shot up another car of a rival gang member. So weeks later, after the shooting incident, police pull Riley over. He had expired tags, so they had the right to pull him over. So they pull Riley out of the car, they search his car, they find handguns. So they want to get Riley on the charges. They were just looking for stuff in the car. But what they also do is, once the police get their hands on his cell phone, they open up his cell phone and they find information that ties him to the shooting. Until that time, there had been no evidence of him being tied to the shooting. Evidence found on that phone is used to convict him in the shooting. Now, what's the sticky situation? Riley's going to argue that, yes, the cops had the right to search his car because what they were charging with him dealt directly with the car. It didn't deal with what was on his phone. He's going to argue the cop should have never searched his phone because what they had initially pulled him over for, the expired tags, had nothing to do with his phone. And then the phone was used in court and he got convicted of something. So he's going to say that the cops violated the unreasonable search and seizure part of the Constitution. So, do Americans have a right to privacy? It's not explicitly written out in the Constitution, long story short, but there's wording in there that suggests that, yes, Americans should have access to the abortions and they should not have the police search their phones unless there's a specific crime committed involving the phone.